All right, talking with the Appeal Pro, Chad Ruback. And Chad, we're talking about now um, the Supreme Court's ruling on this First Amendment issue of age verification to access certain adult websites, with, I believe, 1/3 of their content being adult or porn in nature that could be deemed harmful to minors. You surprised by the court's 6-3 ruling?
I'm not terribly surprised based on how the oral argument went back in January. Sometimes we'll see opinions by the Supreme Court where it looks like the majority opinion might have been a bit of a compromise to get some of the more moderate justices to sign off on the opinion. They might need to tone down the language a little bit. That didn't happen here. This language is as conservative as it could possibly be, written by one of the more conservative justices on the court, Justice Clarence Thomas. There was no compromising, there was no horse trading in getting the 6 judge majority here to sign off on this opinion.
Is it the opinion of the justices, the 6-3 majority, that imposing this age verification protects minors and really does no First Amendment harm?
Exactly. As an initial question, the Supreme Court looked into what standard by which they should review this issue. How much deference they should be giving to the Texas legislature, which passed this law, versus what sort of constitutional scrutiny was required. The Supreme Court determined that it did not require the highest level of scrutiny, did not require an extremely zealous level of scrutiny, but ultimately, based on how the opinion was written, it didn't really much seem to matter what level of scrutiny was applied. The Supreme Court justices, the 6 justices, the majority here, seemed like they were dead set on allowing Texas's law to proceed exactly as passed by the Texas legislature.
So for the digital industry, especially the digital porn adult website industry, what does this do to them?
They're going to have two options. They can either disable access to everyone in Texas. That means anyone with a cell phone in Texas, anyone with an internet connection in Texas just can't access the website at all. Or alternatively, they can implement this age verification requirement. To implement the age verification requirement, the Texas law requires them to either get a photo ID, like a driver's license, passport, that sort of thing, uploaded to confirm someone is of certain age, or a similar verification by commercially available means. One possibility envisioned by the Texas law would be providing bank account information to show that you really are of the person you say you are and of a certain age. I can't imagine many people are going to be really eager to upload their bank statement to a porn website. In theory,
Or
it's
their driver's
possible, but I
license?
don't imagine people are going to be eager to do that. But frankly, the position taken by the porn industry trade group, which was the plaintiff in this lawsuit, was people aren't going to be very eager to upload their driver's license or passport up into a porn website as well. If they're going to do that, they very well might just decide, well, I would rather not participate in this particular website. I don't want this content so badly. Someone might think that I'm going to send my driver's license over to the porn website. The law provides that the porn websites are not required to keep this information. They're not required to save a photo of the driver's license. They're not required to save the driver's license number. But frankly, I can imagine some consumers of porn websites are going to be a bit skeptical. Okay, if someone uploads their driver's license up onto Pornhub, do they really trust Pornhub to do what Pornhub says they're going to do with that driver's license? So I would think that this law, regardless of which course that a porn website is going to take, stopping access to Texans or requiring Texans to upload a driver's license, either way, I think a lot fewer Texans are going to be accessing porn online now.
And of course, other states may very well follow suit if they haven't already.
Many states already have. I think it's over a dozen already have similar laws here. To the extent that these laws are deemed, comparable to Texas law, I would think that the Supreme Court ruling would apply equally to them. But unless they could somehow, the plaintiffs could somehow distinguish um, a law in a different state, for example, to the point that a federal court is going to say, well, this is wholly outside the purview of the U.S. Supreme Court's decision in the Texas case. Outside of that situation where there's a very, very different type of law, I think that the laws in all those other states that have enacted similar laws are going to be similarly deemed valid. And frankly, I think the Supreme Court's decision is going to embolden any states which have not yet enacted such a law to do so quite quickly in the next year or two.
Chad Ruback, thank you, sir, the Appeals Pro, sharing with us about this big ruling from the Supreme Court today. Big ruling
Well,
indeed.
thanks so much, Shaun. I appreciate your having me.